Hey, Lucas, can unpaid bunkers lead to vessel arrest in Brazil?
Hello, Ansam. That is an interesting question and one we receive quite often. In order to answer it, let me walk you through the following scenario. Imagine a foreign client informs that they have supplied bunkers to a certain vessel in a foreign port. Bunkering was requested by the charterers and received on board as evidenced in a bunker delivery note signed and stamped by the chief engineer. However, neither charterer nor owners paid the bunker invoice. So client needs assistance as the vessel is currently calling a Brazilian port. That's a common scenario for many maritime lawyers over the world, and I have both good and bad news from a Brazilian law standpoint. First, a bunker credit is considered a lien under Brazilian law, allowing the creditor to seek the arrest of the vessel. But that is not sufficient, and there are other legal requirements that will need to be met. As an important remark, Brazil has not ratified the International Arrest Conventions. These prevent a creditor from seeking the arrest of a vessel in Brazil as security for a claim subject to another jurisdiction. The arrest in Brazil is often a preventive measure to serve as security for the substantive claim, and claimant will need to have Brazilian jurisdiction for that claim. The requirements for Brazilian jurisdiction are provided in the Code of Civil Procedure, which states the following. The Brazilian judicial authority has jurisdiction where 1. The defendant is domiciled in Brazil. 2. The obligation is to be performed in Brazil. And 3. The case results from a fact or an act performed in Brazil. In our case, the bunker was supplied abroad between foreign parties through a foreign contract not performed in Brazil and possibly containing a foreign jurisdiction clause. So in that scenario, the elements for Brazilian jurisdiction are not present. However, there is light at the end of the tunnel. Brazilian arbitration law expressly provides that prior to commencing arbitration, the parties may seek provisional measures of protection and urgent relief from a judicial court. So, if the arrest arises of a contractual relation that is subject to arbitration, either in Brazil or abroad, the parties may seek an injunction at a Brazilian court before commencing arbitration. Coming back to your initial question, can unpaid bunkers lead to vessel arrest in Brazil? The answer we lawyers all like to say is depends. Bunker credit is of privileged nature, allowing the arrest of a vessel. However, there are jurisdictional and procedural elements to be met. If you would like to know more about ship arrest arising out of bunker credits, stay tuned for the next Snippet 3 live conference, where we will bring an analysis from different jurisdictions around the world.
All right, thank you very much. Looking forward to it. Bye.